And visiting, of course, with our constitutional law expert here in North Texas, David Cole. David, we like to talk to you about the complicated because you make it clear. And this issue before us today is complicated. Parents from victims, those who lost their lives in the Uvalde shooting, are in a California courtroom today. First time they've been in a courtroom. But this is a challenge against Meta, Facebook, Instagram, Activision, and the maker of the gun,
Mhm.
Daniel Defense, that was used in that massacre at Robb Elementary. Uh, what is it they are seeking in this restraining order effort?
Yeah, so they're suing some of the biggest companies in America, right? These major gun manufacturers, huge game company, great big social media platforms, and none of those people were there on that day in Uvalde, right? All those companies were off somewhere else, probably had no idea what was going on, except they may have seen it on the news. They're trying to connect a chain of events from what happened in that school that day back through the fellow that brought the firearm to campus and started shooting back to how he got the gun, got interested in it, and so on and so forth. They're trying to draw the chain back from the events of that day to the things that they claim set it in motion, the decisions
So
made by these larger companies.
that
And
includes, I guess, advertising on social media. That includes a video game, Call of Duty, where this particular gun is the featured weapon.
exactly. There's the claim. There's a couple of different levels to this, but there's a claim about against the gun manufacturer for sort of selling to people like the buyer that ultimately dealt the harm in Uvalde. There's a claim against Activision for selling a game that essentially teaches you how to operate that kind of firearm. And there's claims against the social media companies for making the other companies look good, for sort of glamorizing a certain way of conducting yourself around firearms, a certain way of acting. And all three together, the plaintiffs say, even though none of them were there, put in motion a chain of events that was going to end up in violence somewhere, someday. And it
Do
just
they
happened to be in Uvalde. It could have been anywhere else.
do they also argue that the algorithms in the social media kept putting this weapon, this game, in front of the eyes of the shooter before he was even 18?
Yes, and that's one of the. So we go from the chain of events to what are the legal issues here? The social media companies and gun companies have been named in this sort of case for a long, long time, and there are laws in place that try to define what their responsibility is. For the social media companies, it's Section 230 of the Communications Decency Act, and to make a long story short, it basically tries to treat internet service providers and the metas of the world as being kind of like the phone company or the electric company. Like the electric company is not liable if you use electricity to commit a crime, right? And so their argument is that Section 230 is just like that. All they do is let traffic go by. They charge a fee for that. What happens on that traffic is their business, not the business of the companies. But one of the arguments that's developed in these cases is no, you're not like the power company. You have algorithms that actually go into the flow of information on your site and you adjust it and send it to people who you think are going to be more interested and want to interact with it more. Our company doesn't do that. Phone company doesn't do that when you pick up the phone to call somebody. And so that's been a developing area of litigation. The companies say, same old, same old. All we're doing is just facilitating the flow of information through the pipeline. What that information is not our concern. But lawsuits like this say, no, wait a minute. When you're matching up certain kinds of messages, and particularly harmful messages, with people that really shouldn't be getting them, you get outside of that Section 230 protection and you start to have a claim that can be raised in court.
So let's talk for a little bit about the lawsuit against the maker of this weapon, Daniel Defense.
Mm-hmm.
How is this different, if it is, from the lawsuit brought by the parents in Sandy Hook of the makers of the AR-15, where they won a huge settlement? How is there differences here?
Well, they're following the same playbook. The social media companies have Section 230. The firearms manufacturers have a similar law that basically does not allow state court civil liability for the use of a firearm unless there are certain exceptions. It's defective, it blows up, or something like that. And the firearms manufacturers have used that law aggressively in the last 15, 20 odd years since it's been passed to defeat a lot of claims about the use of their product. What they did in the Sandy Hook case that was clever was to say that doesn't apply. And they brought a suit based on consumer protection laws. that don't have a whole lot to do with firearms, but have a lot to do with information, what you say about the weapon, similar to their claims against the social media companies. And so they kind of made an end run around the law that way, and were ultimately, I don't know if they didn't take it all the way to the top of the court system, but they were successful enough that the gun companies thought it was a good idea to settle rather than risk a much worse outcome in court. Now, that law is the subject of a lot of disputes still about how much force it has, doesn't really apply. But they've taken that same page from the playbook and run it here and said, our claim against you isn't so much about your firearm and how it works. It's about what you said about it, how you marketed it, and how you did it in league with these other people and institutions that deliberately pushed your message to the very kind of person that shouldn't have been getting it.
So if the parents from Uvalde are victorious, that would be like a landmark decision, is what I'm understanding.
It would be a landmark for this stage of the case. If they got in the game, right? That's what this is about here is, are you in the game? Is this even a thing? Do you even have a claim? Because these laws that the Meta and that the gun companies are relying on are very broad, very powerful laws designed to basically insulate them from litigation about certain activities. If they can make a crack in that armor and get behind it, then they get to pursue discovery, then they get to build their case, then they go to trial, and that could really have some adverse consequences for the defendants. I suspect what may happen is something kind of like Sandy Hook. If they get that crack in the armor to work for them, the defendants may get real interested in settling all of a sudden rather than creating legal precedent. Remains to be seen, but it happened with the Sandy Hook case.
And let me press one more. There was a TikTok case a couple of 3 years ago, Blackout challenge, where a
Yes.
10-year-old, following what she was seeing on TikTok, killed herself.
Yep.
And I believe the family prevailed in that case, or at least the courts suggested that social media like TikTok or those being in court today could be, to some extent, liable for what they are showing. Am I right?
That's right. Where these defenses break down is when these people are out of the core business these laws protect. I mean, Section 230 protects you as long as you're just letting messages go through the line, like the phone company. But when you start intervening in what actually is being said and who it goes to, that protection starts to go by the wayside. TikTok had a problem in that case. TikTok also got a lot of attention a few years ago with that devious licks thing where people were stealing all the bathrooms at schools.
Right.
And I don't know if they got sued for that, but they got a lot of bad publicity and a lot of very angry school administrators. And they took steps to mitigate it, which shows that they probably had taken some steps to encourage it in the first place. The algorithms are kind of like the advertising deals that some of the social media platforms have, where they say they don't do anything about content, but they get paid and make money based on how many people look at those things and click. So the lines aren't quite as clear cut as they might like. And that sort of case shows when the operation of these algorithms can begin to get outside the boundaries of what the law has traditionally protected. That said, the company's entitled to have an algorithm and the phone company's entitled to put its wiring in. And their argument's still going to be, and it's got support, that we're just a fancy phone company. All we're doing is facilitating the flow of information, and what people may choose to say is just not our concern.
And the Supreme Court has not given us a definitive answer on this question.
Right. The Supreme Court has taken a couple of cases in this area, and I think had second thoughts and sidestepped one a couple of years ago that involved Google. And every year they get a bunch of people expressing desire to have them review it, and they keep kicking it down the road. I think they're hoping that Congress is going to overhaul Section 230 and do something comprehensive to it. But in today's legislative climate, I don't think that's the highest priority for anybody, really.
That's the great mind of David Cole, again, making the complicated clear for us today, as the parents of those lost their lives in the Uvalde shooting are in court in California against Meta, Facebook, Instagram, Activision, and the maker of that weapon that was used in that massacre, Daniel Defense. David Cole, thank you for sharing with us.
Difficult case, important issues. It's going to be really, really interesting to see what happens there.